The Honorables, the presiding judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court.
Good afternoon and welcome to the Court of Appeals. My name is John Tyson. I'm joined today by my fellow judges, Judge Hunter Murphy and Judge Fred Gore. We have one case on the docket for argument this afternoon. It's a state versus Willie Womble. Are there any preliminary matters to come before the court? Either party.
Not from the state, Your Honor.
Okay, all right. Then without further delay, then we will hear from the appellate. Mr. Weldy?
Thank you, Your Honor. Good afternoon. May it please the court, my name is Jeff Welty. I'm an attorney with the Department of Justice, and I am representing the state of North Carolina in this matter. In 1975, Willie Womble confessed to participating in a murder. That confession may have been false, but no court has ever found that it was coerced or fabricated, and the best available evidence suggests that it was neither. There was no legal error in Mr. Womble's arrest or conviction, nor in the blood draw that was subsequently performed while he was in prison. As a result, Mr. Womble's current murder charge and the DNA evidence that supports it are not the fruit of any poisonous tree. Nor was Mr. Womble entitled to expunction of his DNA after he was deemed innocent of the 1975 murder. Police regularly collect photographs, fingerprints, and other evidence from suspects who are ultimately absolved of responsibility, and that evidence is routinely retained for use in future investigations. Your Honors, the parties have briefed a number of issues, but pending whatever questions you may have, I'd like to focus mainly on two: the lower court's holding regarding the law of the land clause and Mr. Womble's entitlement to automatic expunction, and Mr. Womble's fruit of the poisonous tree argument.
Let me ask you this, Mr. Welty. Looking at Judge Badur's order, is the only issue the state is challenging from the order is the finding that the statute did not contain a per se expunction? Is the state satisfied with everything else in the order?
The fundamental flaw in the order from the state's perspective is Judge Badur's holding with regard to the automatic expunction. Judge Badur didn't reach every issue that was raised by the parties below, but that is the main issue that we're contesting at this time.
So as far as you are advocating in behalf of his findings and conclusions that the draw was lawfully taken, lawfully retained, and you do not see any error in his counsel before the Innocence Commission, correct?
Yes, that's correct. Judge Badur correctly resolved, in our view, the ineffective assistance argument, as well as the arguments relating to the 2009 draw and the 2017 reanalysis of Mr. Womble's blood.
Now, you've stated that there has been no challenge by Mr. Womble to that his confession was coerced, either at the first trial or before the Innocence Commission or before the three-judge court. Is that correct?
Your Honor, Mr. Womble didn't move to suppress his confession prior to his 1976 trial. He didn't appeal alleging any error in his confession. He didn't file a motion for appropriate relief or any habeas proceeding, any type of collateral attack regarding the validity of his confession. His confession was addressed before the Innocence Inquiry Commission, but neither the commission nor the three-judge panel that grew forth from it found that there was any error committed by Detective Leathers of the Durham Police Department when he questioned Mr. Womble.
Also, is it true that there was no objection made to the detective's testimony at trial either?
I believe that's correct, Your Honor. Mr. Womble did testify in his own behalf at trial, and he testified to his perceptions or beliefs regarding that interrogation, but there was no objection to the admissibility of Detective Leathers' testimony regarding the confession.
Turning to the conclusion from Judge Badur that the statute is unconstitutional by not having an automatic self-executing expunction, when someone is found to be innocent. I want to focus a little bit on exactly what the Innocence Commission was. Under the statute, it addresses either a pardon of innocence or a decision of an appellate court. Where exactly does the Innocence Commission's holding, which one is it?
Well, it's neither, Your Honor. The statute that you're referring to, of course, is GS 15A-148. And as you've noted, that statute sets up certain requirements for eligibility for expunction. And two of those requirements would be either a pardon of innocence or a reversal by an appellate court. And Mr. Womble has not received either of those things. What he received was a statement or declaration or finding of innocence from a 3-judge panel of Superior Court judges.
Well, in terms of the statute that controls the 3-judge court does say there's no appeal that can be taken. Is that correct?
It does. Of course, that doesn't make the panel itself an appellate court. It just means there is no further route of appeal from its rulings.
What is the role of the 3-judge court on reviewing the Innocence Commission's? Is it a recommendation, or is it a review of an agency decision? What role is the 3-judge court vis-a-vis the Innocence Commission's decision?
The Innocence Commission makes a finding that there is sufficient evidence to warrant judicial review. The review itself is meant to be conducted by the 3-judge panel. Although in this case, a difficulty with that system became apparent, which is that the 3-judge panel didn't conduct an evidentiary hearing. No re-examination was affected, and instead the 3-judge panel ultimately decided this case based exclusively on the record developed by the Innocence Inquiry Commission and its staff. And the commission itself is not an adversarial process, as I'm sure Your Honor is aware, but rather depends on its staff to identify and tee up cases.
Is the 3-judge court bound by the factual determinations of the Innocence Commission?
No, it's not. And in fact, the Innocence Commission didn't make any factual determinations other than its conclusion that there was sufficient evidence of innocence to merit judicial review. The Innocence Commission didn't make any findings or determinations regarding Detective Leather's interrogation of Mr. Womble in 1975, and that wouldn't have been an issue that was properly before the Innocence Commission in any event.
Did the 3-judge court rely entirely on the record that was developed before the Innocence Commission?
Yes, it's clear that it did. Both then District Attorney Sam Curran and Defense Counsel, in addressing the 3-judge panel, indicated that they had received thousands of pages of materials from the Innocence Commission, and they had reviewed those materials, and they expressed their views about what those materials contained. So again, there was no adversarial or evidentiary hearing conducted by the 3-judge panel, and it likewise did not make any findings of fact regarding Detective Leathers or his interrogation of Mr. Womble. And because this court is not a fact-finding body itself, the state's position is that this court should not be the first to make a factual finding regarding the propriety of Detective Leathers' interrogation of Mr. Womble.
Is that issue properly before us?
Well, I don't believe that as you've noted, there's no appeal from the 3-judge panel's determination. We're certainly not contending there was anything improper or that we're not bound by the outcome of that. But this court isn't in a position to reverse or pass upon it, but it also isn't informed by any factual findings from that court. Your Honor, you mentioned that 15A-148 contains these requirements of either a reversal by an appellate court or a pardon of innocence, neither of which Mr. Womble has. I would emphasize that those aren't just set out in passing in that statute. The requirement of a pardon of innocence or a reversal by an appellate court is reiterated not once but twice in the statute in subsections A and B. Now, Mr. Womble, cognizant of the fact that he's not the recipient of either of those things, has argued that the statute should be construed or read broadly in light of what Mr. Womble contends is its remedial purpose. But the role of an appellate court in construing a statute in light of the intent or purposes of the legislature in adopting it That's a technique of interpretive construction that the court might use when the text of a statute is unclear. The text of this statute is very clear, and this court and our state Supreme Court has emphasized that when the text of a statute is clear, it's binding. The text of this statute requires a pardon of innocence or a reversal by an appellate court.
Let me ask you this. What is our standard of review of Judge Bedour's order, and how do we treat his findings of fact?
This court reviews de novo any legal conclusions by Judge Bedour, but reviews the findings of fact to determine whether they're supported by sufficient evidence.
Did you accept or take exception to any of his findings of fact? Did the state do that?
No, Your Honor. As we discussed at the outset, the state was generally satisfied with the factual determinations made by the court below, but disagrees with the legal analysis.
Turning to the central issue is whether or not the expunction provision, presuming it's within the statute, whether or not that should be self-executing. And I don't want to pace your argument for you, and I certainly want to give you plenty of time to address all issues you want to address. But I'd like to, it seems to me that the main argument here is the authority of Judge Bedour to have declared the statute unconstitutional in requiring an expunction to be initiated by the state. Do you want to go ahead and address that, or do you want to go to the other argument?
Certainly, Your Honor. I mean, you've identified the two main objections that the state has to Judge Bedour's ruling under the law of the land clause. The first is that Mr. Womble's not eligible for an expunction at all under 15A 148, and so can't be eligible for automatic expunction. But the second issue that you've just directed me to is the question of supposing that he were eligible for an expunction, ought the expunction be automatic under the law of the land clause? And there, the court's aware that the law of the land clause is our state constitutional equivalent to the due process clause. And Mr. Womble has argued that this is a matter of substantive due process, his entitlement to an automatic expunction. Of course, substantive due process is an extraordinary standard. Requested relief is required by substantive due process only if it is, quote, implicit in the concept of ordered liberty. And the idea that an entitlement to an expunction would be implicit in the concept of ordered liberty is belied by the fact that not only does North Carolina not provide for automatic expunction, but that Mr. Womble's identified no state that provides for automatic expunction upon exoneration in the way that Judge Bedour has ruled, nor has any court required that. In fact, the state cited a number of cases in its brief where courts rejected the type of automatic expunction argument that Mr. Womble is now making. So finding our statutory scheme for expunctions to be unconstitutional is utterly without precedent, either in the legislatures of our sister states or in our own case law. It would also be entirely at odds with how other identification evidence is treated. When law enforcement seizes fingerprints or photographs or other means of identification, that type of evidence is routinely retained even after a defendant has been acquitted, had his conviction reversed, or been exonerated through some other means. So setting up a different rule for DNA would again be unsupported by the way our statutes deal with other types of evidence.
Mr. Wealthy, does it make any difference if the DNA was obtained through a less intrusive means, such as a cheek swab, or as opposed to a blood draw? Is that relevant at all to anything here today?
I don't think so, Your Honor. As long as the evidence was properly collected, and obviously we'll deal with the fruit of the poisonous tree issue later on, but as long as the evidence was lawfully collected, the specific means of collection isn't relevant any more than it's relevant whether a defendant's fingerprints had to be taken by force. If a defendant struggles and refuses to be fingerprinted and is ultimately compelled to submit to prints, those prints are just as lawfully retained after the disposal of the case as fingerprints that are given by consent.
Mr. Welty?
Would you agree, looking at record page 1432, paragraph 16, the conclusion of the law, the last sentence there, would you agree that Judge Bedore performed a rational basis test, or do you think he was applying some different standard in his analysis?
Well, I'm not sure that that's completely apparent, Your Honor, but I think regardless of the test that Judge Bedore would be applying, there's not precedent to support the outcome. And I think even if you are looking for why the law might rationally allow for the retention of this evidence, it's clear that the retention of identification evidence like DNA or fingerprints serves important social interests, because it's often true, just as happened in this case, that evidence collected in connection with a single incident might later be valuable in connection with another incident. So there's amply good reason for our legislature to have designed the expunction statutes as it did. So whatever level of justification is required, the state's contention is that it's present.
Mr. Welty, have we ever ruled one way or the other if 15A 266.4, I believe it is, the statute authorizing and requiring the DNA sample in this case is a criminal punishment or a civil remedy or civil regulation?
I'm not aware of any ruling on that point, Your Honor. I will say with regard to the collection of DNA upon arrest or upon conviction, that the United States Supreme Court addressed that in Maryland versus King, and in addition to allowing DNA collection upon arrest, rather clearly indicated that DNA collection upon conviction would be permissible as well. I don't believe that it's a criminal punishment to have one's DNA collected any more than it's a criminal punishment to have one's fingerprints taken or photograph taken. I'm not aware of this court having ruled on that question specifically.
And let's assume that it's civil and not ex post facto in this situation. For my next question, if it's civil and we have this later test of the sample, why isn't that an ongoing search, such as what the Supreme Court recognized we need to consider the reasonableness of in State versus Grady when it came to SBM monitoring?
Right, I understand the question, Your Honor. I believe that question of whether a subsequent reanalysis of a sample previously taken constitutes an ongoing search or a new intrusion has been answered in the negative by this court in the Barkley case. In the Barkley case, the defendant's DNA was taken in connection with one investigation. He was exonerated in connection with that investigation. The DNA was then reviewed in connection with the second investigation. And this court indicated privacy concerns are no longer relevant once the sample had already lawfully been removed from the body, and the scientific analysis of a sample does not involve any further search and seizure of a defendant's person. It's essentially a second look under the second look doctrine. If I might, Your Honors, I'd like to turn now to the second major issue I'd hope to address, which is the defendant's fruit of the poisonous tree argument.
Before you go there, let me just conclude with one last question. If a defendant is going back into court to get an expunction and they qualify for it, is that a civil proceeding or a criminal proceeding to seek the expunction?
I guess I don't know the answer to that question, Your Honor. It's within the procedure for seeking an expunction is defined within 15A, but of course a number of things are within 15A that aren't in themselves criminal, including some of our sex offender statutes and others. It's collateral to a criminal proceeding, at least.
Right. So, but isn't there a new number assigned to that proceeding when the expunction occurs before the trial court? Isn't it a, quote, new proceeding?
I don't know whether a new number is assigned, Your Honor. It certainly is a distinct proceeding with its own procedures and standards of proof and is configured separately.
Okay, thank you.
Mr. Welty, just to follow up on that question, are you aware of if there have been any changes to the AOC form or problems with the AOC form, which usually include the insertion of the old case file number, or at least one of the old case file numbers at the top?
I haven't reviewed the AOC form specifically, Your Honor.
And before you move on to that next issue, I just wanted to touch on the parties have discussed at some length U.S. versus Synonym Smith, and whether Judge Bedore could even go into this area. And let's assume for the purpose of this question that we find that or believe that the defendant didn't raise this specific issue. What bearing, if any, does this case have on North Carolina procedure? This seems to be an issue of federal procedural law. It's been 16 years, and I don't want to have flashbacks to the Erie Doctrine, but isn't this a situation where we're just talking about U.S. Supreme Court setting out federal procedure and the powers of the district and appellate courts at the federal level, and is not at all binding on the states?
I don't think so, Your Honor. In Synonym Smith, the Supreme Court never tied its holding to a specific source of law that would be uniquely federal. The party presentation principle discussed there was, as I see it, a structural feature of United States jurisprudence that recognizes that parties are in the best position to know whether a claim is worth raising, and that courts are structurally designed to react only to the issues raised by the parties. It's essentially akin to the rule against issuing advisory opinions, which isn't just a federal rule, but again, sort of a structural common law feature of our jurisprudence. So for that reason, I think it would apply in state court just as much as it would in federal court. And of course, as Your Honor has highlighted, the difficulty in this case is that not only was this issue not raised by the defense, but when Judge Bedore determined that he would rule on it, he didn't call the parties back into court to give them an opportunity to comment on it, to introduce evidence that might be pertinent to it. It essentially came in after the fact with no opportunity for the parties to litigate it up.
And outside of just kind of our common law jurisprudential approach to the adversarial system, is there any statutory or constitutional basis that the state has for having the right to have an opportunity to be heard? Obviously, defendants have many rights protected by the Constitution, but I'm not aware where we have either codified or put in the Constitution a parallel right for the state to be heard.
Right. I don't think it's unique to the state. In other words, I don't think that this is an argument that only the state could raise. I think any party that had a claim adjudicated on a basis on which it was given no opportunity to litigate in the court below would have a legitimate grievance to a reviewing court, that it ought at a minimum to have a chance to go back, be fully heard, present whatever evidence it deemed appropriate. I take the point that there's no specific due process protection for the state, but that doesn't mean that those structural features of how cases are adjudicated shouldn't be available to the state as arguments.
Mr. Welty, before you go forward to your last argument, I do understand from the briefs that the survey of the states showed that the majority of the states do require the defendant to initiate the petition. You want to take just 1 minute and cover that before you move on?
The relevance of that, Your Honor, is simply to the point of whether automatic expunction is implicit in the concept of ordered liberty. The fact that automatic expunction is the exception rather than the rule, or almost that almost understates the case, but the relevance of that is that if an entitlement to automatic expunction were indeed implicit in the concept of ordered liberty, one would think that that would be reflected in the thoughts and rules created by all the state legislatures across the United States. So for that reason, we think it's indicative of a lack of a substantive due process entitlement to automatic expunction.
Thank you.
And Mr. Welty, just to piggyback on that, the defendant did not raise any arguments related to cruel and unusual punishment for a record to remain of somebody that is found not guilty or the case is dismissed, correct?
Not in the lower court and not in this court either, Your Honor. Turning now to the second major issue I hope to touch on, which is the fruit of the poisonous tree argument. Mr. Womble argues that his DNA was taken as a result of the unlawful interrogation by Detective Leathers in 1975.
So this argument has to go back to the original charge, the original murder charge that in 1975. Is that correct?
That is the supposed tree, Your Honor. Yes, all the way back in fact, before the charge or before the trial. It goes back to the investigation of the murder in 1975 and Detective Leather's initial interrogation of Mr. Womble.
Well, you touched on this preliminarily, and I don't want you to, rehash the grounds that you've already said, but I think you said there was no motion to suppress, there was no challenge to his testimony at court. It was not raised on the appeal before the Supreme Court. It was not raised before the Innocence Commission or before Judge Badur. Is that correct?
It was not raised at trial or on appeal or in post-conviction. The nature of the interrogation was discussed before the Innocence Commission, but the Innocence Commission and the three-judge panel made no finding regarding the propriety of Detective Leather's interrogation of Mr. Womble.
Was it made in relation to Mr. Womble's ability to understand and his educational and functioning level? Is that the context in which it was raised?
Before the Innocence Inquiry Commission, that was part of the discussion, yes. Mr. Womble testified to his limited reading ability. Of course, Mr. Womble's version of what he did and why he did it has changed dramatically over time, which perhaps creates some question about the veracity of what he has to say. However, I see that my time, but for my rebuttal time, has expired, and in the hopes of reserving my remaining time, I would just ask the court to reverse Judge Badur's order of suppression and remand for further proceedings.
Okay, well, one last thing. Mr. Womble also claimed he was under the influence or was high at the time he was interviewed. Is that also correct?
He testified to that at trial, Your Honor, though by the time he appeared before the Innocence Inquiry Commission, he had changed his story and said it wasn't an inability to understand. In fact, before the Innocence Inquiry Commission, he admitted that he understood what the confessions contained, but he changed his story and said that he was physically coerced, which was the first time that particular version had ever been presented.
Mr. Welty.
You want to reserve it? Go ahead, Judge Murphy.
Just real quick. Again, there was no objection to finding of fact 46 on record page 1430 regarding Judge Badur's finding that defendant suffers from intellectual disability and borderline intellectual functioning, correct?
That's correct, Your Honor. We don't contest that Mr. Womble has limited intellectual functioning. As you know from our reply brief, we contest the extent to which that was portrayed in the defendant's brief.
Thank you, sir.
Is it also true there's been no adjudication of incompetence or inability to take care of himself?
As far as I know, that's correct, Your Honor. That certainly has never been identified in this litigation.
Okay, thank you. We'll reserve the rest of the time and thank you.
Thank you.
We'll hear from the appellee.
Thank you, Your Honor. Good afternoon.
Good
May it
afternoon.
please the court. I'm Narendra Ghosh of the Durham County Bar. Along with Jay Ferguson and Bradley Bannon, I represent the defendant, Mr. Willie Womble. Mr. Womble, an intellectually disabled Black man, served almost 40 years in prison for a crime he did not commit. In 1976, he was found guilty of first-degree murder because a police detective coerced his confession and then repeatedly lied about it at trial. Mr. Womble was imprisoned until 2014 when he was exonerated. After the state admitted that Womble was innocent, that the detective illegally obtained his confession, and that the detective testified falsely, a three-judge panel found Womble had proven his innocence by clear and convincing evidence. Now the state seeks to exploit Womble's wrongful conviction by using evidence against him that it acquired only because he was incarcerated. The state cannot be permitted to do so. The trial court correctly granted Mr. Womble's motion to suppress. I'll be focusing on two issues: the constitutional violation found by the trial court and our principal alternative claim that the DNA evidence must be suppressed as fruit of Mr. Womble's wrongful conviction. Before I do that, I do just want to touch briefly on the procedural background here at the three-judge panel. To clarify, the Innocence Commission simply makes a determination that there's sufficient evidence to warrant a three-judge hearing. The three-judge hearing is a de novo proceeding. There's no reliance on what the Innocence Commission found or decided. It is a new proceeding, which provides to be adversarial and with witnesses and evidence. The only reason that we did not have witnesses here is because the district attorney, Sam Curran, made admissions of all the pertinent facts. He admitted that Mr. Womble's confession was illegally obtained. He admitted that Detective Letters lied about it at trial, and he admitted that Mr. Womble was factually innocent. So given those admissions, there was no need then for the three-judge panel to conduct any sort of hearing. Just based on that, it was able to make its determination that Mr. Womble was innocent by clear and convincing evidence.
Let's take the judge's order as given. As a threshold matter, how can you show entitlement for your client under 15A148 with the language, with the statute as written? Has your client received a pardon?
No, he has not, Your Honor.
Did he receive a judgment from an appellate court?
I believe under this statute, the three-judge panel should be deemed an appellate court. The
So
three-judge
you would
panel.
go into that prong and not the pardon prong, correct?
Yes, Your Honor.
So you wouldn't make any claim to any entitlement to an expunction only as treating the three-judge court as an appellate court?
Yeah, well, just to be clear, I mean, our under 15A148, the three-judge panel should be deemed an appellate court. As the trial court found, Mr. Womble is also entitled to an expunction regardless of the wording of the statute. Yes.
So the statute, so there would be a right, you're arguing there's a right to an expungement irrespective of the statute?
That's correct. And that's how the trial court ruled. I would direct the court's attention to the trial court's conclusion of law number 16, page 1432 on the record. It's the kind of the middle of that paragraph, the fourth sentence, where the court said, this court finds that it is an unconstitutional burden on the defendant to require him to affirmatively seek something he is entitled to, after exoneration or return insofar as possible to the status and posture he shared with all other uncharged citizens prior to the wrongful conviction. So what the trial court is saying.
Would that include fingerprints and photographs as well?
I mean, that not reached here, and that his fingerprints or anything were not an issue.
Well, I understand that's the analogy. The states said that there's nothing that requires, even on innocence or finding them not guilty, for the state to cleanse its data bank of fingerprints and photographs, and they question why the DNA evidence should be treated any differently from that, particularly with in the arguable absence of a statutory right.
Well, two reasons, Your Honor. First, fingerprints and such are based on arrests, and if those arrests are valid, even if there's no ultimate conviction, the records based on the arrest can stay in the system. Here, Mr. Womble's blood was taken solely based on his conviction, not on his arrest or a search warrant or any other order. His blood was taken solely because of his conviction, and that conviction was overturned.
Counsel,
so the only basis for
on that issue, solely because of his conviction, was there not a potential compliance of him to fall under the Bowden class of defendants for him to participate in early release? Was it that part of the blood draw as well as for him to qualify if he ultimately had fallen in that class of defendants to be released as well?
Yes, I mean, that is how what happened is based on the Bowden litigation, there appeared to be a possibility that Mr. Womble would be released, and so his blood was seized before he could be released.
So are you challenging Judge Badour's finding that the draw was legally taken and it was legally retained? Are you challenging that finding in the order?
I mean, I believe those are whether that was lawful is properly a conclusion of law. And we have argued, and which is principally our third claim, that the crime lab's conduct in 2017, when it re-examined his blood, was a violation of the Fourth Amendment. So, the trial court's order doesn't expressly discuss our Fourth Amendment claim about 2017, but if it's to the extent that it's read to be ruling against us on that claim, we do challenge it. Have challenged it.
How do you distinguish the Barkley case that the state on the second look?
Well, the key in Barkley case and basically every other case that the state relied on is that the original basis of the blood draw, or the original basis of the DNA extraction, was still valid. In Barkley, it was actually by consent, and that the defendant there had consented to the blood draw, and in fact, the trial court had re-examined the nature of and scope of his consent, and found that the consent encompassed the use that the state put the blood to, and this court then affirmed that. So you had the original basis for the extraction was valid. Here,
did your client raise any objection at the time the blood sample was taken? Did he object to it, or did he realize that that might be a path for him to get early release at that time?
I'm not aware of anything in the record concerning Mr. Womble's reaction to the blood draw in 2009.
But there is no objection in the record from him at that time, correct?
No, and he was not represented by counsel at that time.
So you are challenging the legitimacy of the draw? You're challenging Judge Baddour's finding that it was legally obtained and legally retained?
Well, we challenge it as first of all, as fruit of the poisonous tree, that it is fruit of the constitutional violations in 1975 and 1976. So in that sense, again, that's an issue that Judge Baddour did not reach and did not address in any way. So, because the blood draw in 2009 was the result of the constitutional violations in 1975 and 1976, we don't think it was lawful.
Thank you.
And the other issue, coming back to Your Honor's questions, or a couple of questions ago, asked why is this not like fingerprints, and the state repeatedly argued that the statutes permit them to retain this. I do not think that's correct. The federal law provides a structure for the CODIS system, and they provide that there's statute and regulations that the states must follow to participate in the CODIS system. And under the federal system, a state is required to remove DNA samples when a defendant's qualifying conviction is overturned. So it's once. So if someone's DNA is only there based on a conviction, once that conviction is overturned, they're no longer supposed to be in the DNA system. And yet, actually, what happened here is that in 2017, even after realizing that Mr. Womble's conviction was overturned, the state crime lab proceeded with the reanalysis of his blood, and then the release of, and then sending those analysis to the local police department.
Would you agree that if we would hold the blood was lawfully taken, the sample was lawfully taken, lawfully retained, then the state crime lab could have lawfully taken the second look? Doesn't your argument depend upon the threshold that the sample was not lawfully taken?
Well, I think that the critical thing is by the time that Mr. Womble's conviction was overturned, they then had no basis to retain it or to reanalyze his blood. Okay,
now you mentioned that CODIS requires a procedure to remove samples upon certain events. The state's arguing that North Carolina statute, presuming that you're within that statute, that it allows It's consistent with the majority of the states to put the burden to initiate that process on the defendant. Why is that? How can Judge Badur's conclusion of a self-executing expunction be consistent with the majority of the states that hold that the defendant must initiate it?
Well, I think Judge Badur's determination comes down to the most basic principles of due process, which is that when a defendant's conviction is overturned and the charges are dismissed, the defendant must have his liberty fully restored. He must be relieved of all consequences of the conviction. As the Supreme Court held in the Nelson case, which we recently provided, all property taken from him based on his conviction must be returned to him. The state held Womble's blood sample and DNA profile only as a result of his 1976 conviction. To fully restore Mr. Womble's liberty, due process required the state to also expunge Mr. Womble's DNA profile and dispose of the blood sample.
Could you also say the reason that the state had the blood sample was because of the Bowden case, which would have authorized an early release from Mr. Womble if that case had not been overturned, and that he was treated the same way as everyone within that class of defendants? Isn't that the triggering event?
We don't dispute that he was treated similarly to other incarcerated individuals. The difference is that, unlike all those other incarcerated individuals, Mr. Womble's conviction has been overturned. And that conviction was the only reason he was in prison. I mean, if there were other convictions that he was serving time for at the same time, that'd be a very different question. But here, his conviction in 1976 was the only basis for his incarceration. And that qualifying.
I'm sorry, go ahead. I'm finished.
And that conviction under the CODA system was the qualifying offense that entitled the state to, put his information into the CODA system.
Now, going back to your fruit of the poisonous tree, the only basis for that would be the original confession. Is that what you're challenging back in 1976? Is that the basis of a fruit of the poisonous tree argument?
So the fruit of the poisonous tree arguments are based both on the fact that his confession was coerced and the detective's repeated acts of perjury at trial.
Okay, now the state has argued that those issues were not raised. There was no motion to suppress. There was no objection to the testimony. It was not raised before the Supreme Court, and it was not raised on any post-conviction review. And it appears before the Innocence Commission, you raised his ability to understand what he was signing through his mental ability more than the fact that the officer had coerced confession. How can you reconcile that, this issue, if this is an issue and it goes all the way back to the beginning, why haven't you waived that by not bringing it forward?
Well, I respectfully disagree with the state's characterization of the Innocence Commission proceedings. First of all, it's not, again, the Innocence Commission proceedings are not adversarial. It is the commission who runs that. Mr. Womble, I don't think even had counsel at that point. He's not putting on evidence. But certainly one of the issues in those proceedings was whether or not Detective Letters coerced the confession out of him, because the confession was the only evidence of guilt here. The only issue, in order to find him innocent, someone has to say that confession was false, and you have to explain, well, how was there a false confession? And that's why there was testimony, including from Mr. Womble, about how that confession was coerced from him. And then that issue
do you agree that no one from the law enforcement or from the victim's family or anyone connected to the original crime was examined or produced any evidence at the innocence hearing, correct?
I agree. To my knowledge, no one from the victim's family or from law enforcement was testified at the innocence hearing, but I don't know of how any of their testimony would have changed the outcome.
the officer had died by that time, but there were other officers from the original investigation who were available to be called before the commission. They were not called, correct?
That is correct, but I don't believe those other officers would have changed the result because they were not there when the confession was obtained. In fact, and in fact, in subsequent proceedings, two of those officers were deposed, and their depositions are part of the record here. And they talk about some parts of what happened during that initial investigation back in the 70s, but they were not present when the confession was obtained. So the only people in the room were Mr. Womble and Detective Leathers, who, as you said, is no longer alive.
So how can we aren't you asking us to revisit the merits of that issue that's already been litigated and already been resolved?
I believe it has been resolved definitively by the three-judge panel and by the state's admissions during that proceeding.
Isn't the three-judge panel based upon really just the stipulation of the DA? Isn't that the reason no other evidence was brought in and no other testimony was made?
Yes, the admissions of the DA are the reason that there was no other testimony brought in. Because the DA admitted that the confession was unlawfully obtained and that Detective Leathers lied and that Mr. Womble was innocent, because the state admitted all of those things, then there was no need for an evidentiary hearing. And those admissions are binding on the state now.
So you're saying that the DA made his agreement to setting it aside, dismissing the charges based upon his express finding that your client had been coerced? Is that what you're saying?
I mean, I will pull up his exact language. He stated that he had fully reviewed the record, and in describing, what happened, he said this crime, quote, was solved because of the illegally obtained confession. And that he stated that the detective, quote, told absolute falsehoods, quote, when discussing the confession.
And is that in the three-judge panel's order? Is that a
That is in
final
the transcript of the three-judge panel's, the proceeding before the three-judge panel.
Understand that. Understand this might be testimony or evidence presented, but is there a finding in the three-judge panel's order showing that your client was coerced, that his confession was coerced?
No, Your Honor. The panel did not make a specific finding on that. The finding was that he was innocent by clear and convincing evidence.
Well, isn't that debate? Wouldn't that have been the proper place to raise that, and not now for the first time on appeal?
Well, I mean, the Innocence Commission is tasked. I mean, the sole task of the three-judge panel is to determine whether or not Mr. Womble had made out his claim of innocence. That is their sole task. And then if he has made out the claim of innocence, then they reverse the conviction and dismiss the charge.
Okay, again, presuming that your client is covered under the statute and the three-judge courts and appellate court, and again, you're making no claim that your client's received a pardon, and the only basis of a statutory right to an expunction would be us finding the three-judge court to be a quote appellate court. Is that correct? Do I understand that argument correctly?
Well, under the statute,
statutory right.
Yes, under the statute, yes, our claim is based on that appellate
Okay,
court.
now going on to your claim that there's some right under Article 1, Section 19 of the law of the land, the states argued that the majority of states do put that burden on the defendant to initiate that. So why is that the state's choice to use the majority method? Why is that unconstitutional under our Constitution? And what authority did Judge Badur have to make that determination in the absence of any assertion of that claim or defense to it by either you or the state?
Okay. Well, I'll start with the latter part first, which is
Okay.
the authority of the trial court here. And this court has held in both the Colbert case and the Harvey case, cited in our memorandum of additional authority, that after holding a hearing on a motion to suppress, a trial court may grant the motion on different grounds than those raised by the defendant. As long as there's a hearing where all of the relevant evidence is put before the trial court, the trial court, determines the law and can find a legal error, even if that legal error was not specifically argued by the defendant. And those cases have not been challenged in any way. I do not believe that the U.S. Supreme Court case that the state relies upon has any bearing on it. I do agree with Judge Murphy's characterization that it's a prudential rule for the federal courts. And even in that case, the Supreme Court stated that the presentation principle has exceptions and that there are times when the trial court can decide on a basis not suggested by the parties. So
isn't there a mandatory joinder requirement if a statute's going to be declared unconstitutional, that certain parties must be joined to that proceeding and be entitled to defend the statute?
I believe that is only for a facial challenge, I believe, to a constitutional provision, to a facial constitutional challenge to a provision of state law. Here, this was just as applied to Mr. Womble.
Okay, now, so why wouldn't the state have a right to respond to this if the judge is going to rule a state statute unconstitutional? How can they do that in the absence of the right of the state to argue the constitutionality? Statute's presumed to be constitutional. The procedure is presumed to be constitutional. So how can Judge Baddour do that in the absence of providing the state an opportunity to defend the practice?
Well, again, I don't believe that Judge Baddour ruled that the statute was facially unconstitutional or that it's just constitutional per se or that he's striking on the statute. He's only ruling that his ruling is independent of the statute, which is just
okay,
that.
I'm understanding in this case with this counsel, you and the state, that neither one of you raised this nor argued this before Judge Baddour. This completely came out of the blue from is that not correct?
I mean, the precise basis of his order was not argued to him, although the related issue of ineffective counsel was. So obviously the statute was discussed. I mean, the nature, all the facts about the exoneration and about.
And he ruled against you on that basis too. He ruled that your client did receive effective assistance of counsel before the commission, correct?
Yes, Your Honor, that was.
Are you challenging that as well?
Yes, we have, Your Honor.
Okay, so I want to give you time to argue that as well, because I want to make sure all your issues you're given time. And I want you also at some point the state has argued that inevitable discovery and intervening cause that would have necessarily led to your client, irrespective of the DNA too, as a basis to overturn, even if it was excluded, it would have been inevitably discovered. So those are two things I'd like for you to address at some point too.
Okay. Well, mindful of my time, I will address them now.
Okay.
First, on the inevitable discovery, the trial court found and concluded that there was no basis to say that the state would have investigated Mr. Womble had the codicit not been returned to the police department.
Hadn't he already been identified as a suspect or potential suspect even before the tests were returned?
He had not been identified as a suspect, Your Honor. He had been talked to as part of the neighborhood canvass. There were other people who were suspects. For those people, they did criminal record searches. They did trash pulls. They interviewed people. For Mr. Womble, they did none of those things. They did not obtain his criminal records until later. They did not try to do a trash pull. They did not seek to talk to him again until after the CODIS hit. There was a tip.
Didn't the defendant's father-in-law make law enforcement aware of the victim being, quote, bothered by somebody in the complex, and describe who that person was? Maybe not by name, but at least wasn't that the police had information, correct? And also, didn't a relative of your client actually identify your client as the person who committed the murder?
Well, Your Honor, there was an anonymous tip that came in about Mr. Womble, which came in 4 days after the murder. The detectives did nothing with that until after the CODIS hit, until after Mr. Womble had counsel, and counsel filed a motion regarding that. So, this information about Mr. Womble had all come in very early on in the investigation, and none of it was acted upon because they didn't consider him a suspect. They were investigating other people, and they didn't do anything to follow up on any of that until the CODIS hit came in.
Did he identify, did he try to cast the blame on someone else that had some type of relationship with the victim?
I do not recall Mr. Womble accusing anyone else of the crime.
I thought that there was that testimony that he had told the officers that the victim had a relationship with another person and named that person by name for the officers.
I believe either he or his wife identified someone that there was a relationship with. I don't know that they.
And that person was eliminated as a potential suspect, correct?
Eventually, yes, Your Honor.
Go ahead, I'm sorry.
Oh, and then besides inevitable discovery, I was going to address Your Honor's question, I believe, about the attenuation argument.
Right.
Which is that the U.S. Supreme Court has set out 3 factors with regard to attenuation. The most important factor is the flagrancy of the violation. Here, you have the most flagrant constitutional violation possible, where a detective coerced a confession out of an intellectually disabled man and lied about it in order to secure a life sentence against him.
Do you think we have the record before us to make that factual determination? Is that not a factual determination?
I believe that that is supported by the state's admission, that the state has admitted that the confession was unlawfully obtained. And so, although the trial court did not make findings about that, the state has admitted that before the 3 years panel.
Well, if the admission could be unlawfully obtained, that he was under the influence, or that his mental capacity was such that he could not understand the questions, or, I mean, the fact it's illegally obtained is not necessarily based upon, even an admission of that is not necessarily evidence that it was in fact coerced. I mean, there can be a lot of reasons to say that a confession is illegally obtained, correct?
Illegally obtained, I'm not sure, if
he didn't understand, would that be
if he merely didn't understand, and the court and the detective didn't take advantage of that, that I don't see how that's illegal for the detective.
How about if he was under the influence? That would not be a legal confession, would it?
I mean, maybe the confession may not be legal, but here the state admitted it was illegally obtained. It's not just that the confession was involuntary. The state admitted that the confession was illegally obtained, which means that the detective committed misconduct in obtaining that confession.
Mr. Ghosh, let's assume for a minute that the Innocence Commission had gone the other way and the state had not stipulated that it was an illegal confession or a legally obtained confession. And obviously you would have a right to appeal that to any appellate court. Would the finding by the Innocence Commission have prevented you from seeking either an MAR at the trial court level related to the search, or seeking a petition for writ of certiorari after the Innocence Commission's findings to try to challenge the search?
Sorry, is your question whether or not there would have been a basis to, if he had not, if the three-judge panel had ruled against Mr. Womble, would there be some route to appeal that?
No. Would it have barred you being able to seek review of the original conviction still? Setting aside procedural bars and timeliness, wouldn't you have been able to still challenge that in an MAR or PWC?
So I think I'm not aware of a situation where that's come up. I think he could have an MAR. He could file an MAR even if he had there'd been a proceeding before the three-judge panel. I don't know if there would be some sort of estoppel issue based on what the three-judge panel decide. I mean, it would depend exactly, what happened before the panel and how it decided.
And I think that gets into kind of, I think the problem here is, why should the state be bound when the defendant might not have been from an adverse ruling from the Innocence Commission or a three-judge panel?
I mean,
why do those interrelate?
I mean, here it's not just the adverse ruling; it's also the admissions that were made by the state. It's the admissions that are binding. If the state had, if the state had not admitted anything and then, proceeded, they had a hearing with witnesses and there were disputes about, what happened back in 1975, and then the court makes a determination. I would not have the same argument before you here. But what happened instead is that the state made admissions in order to take all of that off the table. And when it makes binding admissions, they remain bound by them.
Well, is that just binding in that proceeding, or binding in all future proceedings between the state and that defendant?
All future proceedings. And I don't think that, the principle of judicial admissions being binding is the principle is needed because you're addressing how the effect of those admissions in a separate proceeding. Obviously, those admissions are effective within the three-judge proceeding itself. The principle of judicial admissions is all about how those admissions apply in other proceedings. I see that I'm way over time. I appreciate the court's indulgence.
We'll give you a moment if you'd like to sum up, Mr. Gove.
For all the reasons discussed, again, both the basis that the trial court ruled on, as well as the alternate basis that we have argued here, including the fruit of the poisonous tree, the trial court was correct to grant Mr. Womble's motion to suppress, and its order should be affirmed. Thank you.
Are there, one moment, are there any other questions from Judge Murphy, Judge Gore? Any further questions of defense?
No.
Judge Gore?
No, Your Honor.
Okay, thank you very much. Thank you, sir.
Thank you.
Okay, we'll hear on rebuttal from the state.
Thank you, Your Honor. I would like to start where Mr. Ghosh left off, which is with the remarks made by then District Attorney Sam Curran before the three-judge panel. Mr. Womble's counsel has repeatedly characterized those as judicial admissions, but a judicial admission must be a statement designed to remove an issue in controversy. And Detective Leather's interrogation of Womble and whether or not it was lawful was not an issue in controversy before the three-judge panel. The sole issue before the three-judge panel was whether Mr. Womble had established his innocence by clear and convincing evidence, and any statements that District Attorney Curran made on subjects other than that one were essentially surplusage. With regard to that issue, it's important to note that the Innocence Inquiry Commission proceeding effectively set the table for the three-judge panel. The panel's distinct in law, but in this case, it was operating based off the record of the Innocence Inquiry Commission, not supplemented by any live testimony. And the record before the Innocence Inquiry Commission was, as has come out in this conversation, not an even-handed record. Mr. Womble testified, Mr. Womble's co-defendant testified, an alibi witness that Mr. Womble had presented in 1976 testified, even though the jury had rejected Mr. Womble's alibi. But no law enforcement or prosecutor or anyone who might have an interest in upholding the conviction testified. Now, Mr. Ghosh has argued that it wouldn't have made a difference if, for example, SBI agent Joe Momier had testified before the Innocence Inquiry Commission because he wasn't in the room when Leathers questioned Womble. That's actually not what Womble said before the Innocence Inquiry Commission, where he testified that Momier was present. But leaving that aside, it still would have mattered because Momier talked to Womble after Womble had confessed to Leathers, and Leathers confessed, and Womble confessed again to Momier when Leathers wasn't there and when Mr. Womble's counsel was there. So that would have been critical testimony for the Innocence Inquiry Commission to have heard. The last point that I'd like to make in my remaining 1 minute relates to the idea that due process requires every defendant who is ultimately found not liable be returned to the same position as if they had never been charged. In this connection, Mr. Womble identifies the Nelson case decided by the United States Supreme Court, which expressly is related only to property and the financial incidents that arise from convictions that are later set aside. It was never addressed in that case that fingerprints, DNA evidence, biometric evidence, or other information of that type would need to be returned to the defendant. And of course, there are many things that people who are charged for crimes and ultimately not held accountable don't get returned: fingerprints, photographs, and DNA among them. Again, there's no evidence supporting the ruling of the court below, and the best factual evidence that we have is that Mr. Womble's confession may perhaps have been false, but was not coerced or fabricated. And for those reasons, we ask the court to reverse the decision by the court below.
Okay. Thank you, Mr. Welty. Any questions of the state? Judge Murphy, Judge Gore?
No.
Okay, we'd like to thank counsel for their good arguments and for the briefs that you put forth. And before we adjourn, I'd like to take a moment to recognize Judge Gore. He has joined our court in January, and it's the first time we've had a chance to sit together, and he comes from the trial bench with a wealth of experience. So I'd like to, at this time, extend a welcome to Judge Gore and officially welcome him to the panel. And if there's nothing else to come before the court, we will ask the clerk to adjourn. Thank you very much.
Yes, Your Honor. This session of the North Carolina Court of Appeals is now adjourned.
Thank you. Thanks, everybody.
Thank you, everyone. Thank you, Justice.
Thank you.